Okay, good afternoon, everyone. We'll get started with our next panel. The lights are dimming. Drama raising. Hello, everyone. My name is Tanya Trujillo. I'm the Deputy State Engineer and Governor's Water Policy Advisor for the great state of New Mexico. I'm happy to be here at CRWUA again. I think this is my 20th year at CRWUA, which is exciting. But it's great to be back here and to be on this panel with a group of colleagues and friends and truly experts in their fields. Our panel title is Keeping the Peace Among the Pieces, Risks of Litigation in the Colorado River Basin. I think just to kind of frame the topic for initial purposes, the tensions are extremely high this year. I think of the 20 years I've been coming to the conference, I think this is probably the one that has involved the least amount of good relationships among the states. I know there's been a lot of discussion of potential claims of litigation and discussion of potential challenges that may be raised against various parties and against some of the actions that have been taking place over the last few years. The main purpose of our panel is to talk through some of those issues and to provide some perspectives from different folks on how some of that might play out. I think I just want to try to start with some initial context of everyone knows there are legal uncertainties and ambiguities about all of those various positions that exist. Everyone knows there's no clear path forward as a result of any potential litigation. So that backdrop is what we're going to be talking through today. We know that lawyers from the upper division states have claims and challenges that they may have in mind. We know the lawyers in the lower basin have claims and challenges that they have in mind. But the bottom line equation is that none of those may result in an actual solution for the challenges that we see holistically across the basin. So I'm going to just briefly introduce the panel, and then we'll kick off with a few questions and comments, and we're hoping for a good dialogue for the next hour or so. So first we have Mike Connor, who is the former Assistant Secretary for the Corps of Engineers most recently, but has also served in many different capacities, including Commissioner of Reclamation and Deputy Secretary at the Department of the Interior. Next to Mike is Jeff Kightlinger, formerly served as the General Manager of the Metropolitan Water District of Southern California and was General Counsel for Metropolitan prior to that. Next is Jeff Wechsler, who is an attorney in private practice from New Mexico, who has been involved in many different interstate litigation matters and currently represents the state of New Mexico in the Texas v. New Mexico litigation that's pending in the Supreme Court. And Betta Becker from the Navajo Nation, who has much experience on matters in the basin and has also been involved in Supreme Court litigation in the context of representing and being a member of the Navajo Nation. So just to kind of get us started, and again, as I said, starting from the presumption that basin-wide litigation is not the preferred course of action, and acknowledging that uncertainty of potential outcomes if litigation is initiated, I'd like to kind of hear some thoughts about what some of the current challenges that litigation might impose on our Colorado River Basin's water management. I think we can look think about this in a lot of different ways. With respect to maybe starting from a little background and thinking about some of the lessons learned from prior cases, I wanted to particularly hear from both of the Jeffs. Jeff Kightlinger can talk a little bit about the background of Arizona v. California, when that was initiated over 50 years ago. And then Jeff Wechsler can talk about the Texas v. New Mexico litigation and some of that. So I'll just kick it over to you guys, and we'll see how we want to frame the next set of questions. Thank you.
So I guess I'm going to go first, and we made it confusing to put the two Jeffs next to each other. I'm going to talk more broadly just about challenges, and I'll name three from entering into litigation. The first one's maybe an easy one. It's like the costs of litigation, right? Trials, litigation are expensive. They're expensive in terms of dollars. They're expensive in terms of resources. And then, as I'll mention in a second, they're also expensive in terms of like trust equity, I think. And one of the examples I'll just give is the Kansas versus Colorado case, which, you know, in that case, there were over 100 days of trial on the model alone. I didn't join and become part of that case until we were simply fighting over the remedies. And so sometimes those, you know, parties have limited resources. They don't have the time and personnel to devote to sometimes more important issues. And really, a lot of thought should go into where should those resources be directed. And a lot of times, the best answer is certainly not litigation. The second thing I'm just going to mention is the harm to the long-term relationship. And in my experience, that's pretty real. Having litigated 5 of these cases, litigation frays the trust between the different states, and you know, in working in various compacts and in context and managing a shared resource, it's really important to have that trust. And once you lose it, everything becomes that much more difficult. It's harder to reach lasting solutions. I'm actually going to give a positive example there, and that is the Texas versus New Mexico case. And the reason I'm giving that example is, sure, the states started out in litigation, but as many of you know, the states are now aligned. They've reached a solution and resolved their interstate apportionment issues. The litigation is ongoing, as I think we'll get a chance to talk about. But the relationship as between Texas, New Mexico, and Colorado in that basin is as strong as I've ever seen it right now. The states are working together. They're addressing a lot of long-term issues that they wouldn't otherwise be able to work on if that trust hadn't been rebuilt. And then the last thing that I'll mention in terms of the challenges, and maybe this is the most important, and that is litigation doesn't typically lead to, well, let me put it this way, you lose control over the solution. The court has a limited understanding of technical water cases. It has a very limited ability to draft nuanced long-term solutions. I mean, they're very smart people on the court. Obviously, the special masters that are appointed are also very smart, but they don't have the kind of understanding of the details and the specifics that are necessary to craft sort of longer-term, real on-the-ground solutions. And that's not what they're set up to do. They're set up to answer the narrow legal question that's put before them, and then, you know, identify a short-term remedy like monetary damages or something like that. And so, you know, whether it's through litigation, and I think we'll have a chance to talk about as well through various settlement, you really lose the ability to craft those kinds of long-term solutions.
Talking a little bit about the Arizona versus California history, and it fits in very well with what Jeff was talking about particularly the unintended consequences. I think that is a case where both states managed to lose, and lose spectacularly. Not mildly, but both really got destroyed in effect by this ruling. And it was classic unintended consequences. I think one of the funnier stories I'd ever heard was after the ruling, the day the ruling came out, there had been an actual debate internally in the California Attorney General's office about potentially settling with Arizona or litigating it out. And since California felt they had the superior legal hand, the litigated out group prevailed in the discussion and said, we're going to win this, let's go push forward. And one of the attorney generals put out a memo to the entire staff, Gil Nelson, saying how California in some respects actually won the case by clarifying these things. The other attorney general who'd been advocating for settlement, Charlie Corker, put out a memo to the entire staff that said, not only did we lose, we lost every single issue and then some, and if California had defaulted on the pleadings, they'd have done much better. Gil Nelson sent out a counter memo really explaining his views. Charlie Corker sent out another memo till the AG at the time, Stanley Mosk, sent out a memo saying, from now on, there will be no further memos by anyone regarding Arizona versus California in this office ever again. But it is a case where, when you look at it, yes, Arizona got far more than they even dreamed of asking for that the court did. And then Arizona also got most of it taken away, and you have Arizona, the strong states' right advocate, ending up with a federal water master that can apportion shortages. You then had the tribes who had intervened in the case that hadn't even been considered in the issues between Arizona versus California. Tribes getting most of the water that Arizona got, and then some. And then finally, on the relationship aspect, California made very, very sure in 1968 to stick it to Arizona and the shortage and through legislation, which hadn't really been contemplated at the time. And so both sides lost in pretty spectacular fashion from 30 years of litigation.
Go back to hearing more of that. We'll have a couple more follow-ups on that, but Bida, did you have any particular lessons learned to pass along from Navajo Nation's perspective?
Sure, and let me just clarify, Tanya gave me a lovely introduction, but I actually did not work on the Supreme Court case. And I think I want to, show of hands, how many people are lawyers in this room? I'm very glad to see that. I think it's maybe a third. Because I think what I want to share with you is maybe I really want to riff off of what both Jeff said. Because, well, one, I was not involved in the Supreme Court case because Supreme Court practice is an incredibly specialized field where it's just a handful of lawyers who actually appear in front of that court. So when we say you lose control, you lose control. And because it's such a specialized field, there are a lot of practitioners who will come when they hear a tribe has a case in front of the Supreme Court. We are inundated with people who want to represent us, and oftentimes for free because it's worth them to just get in front of the court. So point one on losing control. Point two, in harming relationships, there's a famous Indian water rights case out of Wyoming. And of course, I'm forgetting the name of it. Well, let me tell the story, and somebody in the audience will shout out the name. So this was in the 1980s. So think about the time that I guess Jeff K. talked about. The way I like to describe Arizona versus California, very technical explanation is the non-Indians were like, ah, when the court, right? When the court issued what it did on the tribe. They didn't see it coming at all, right? Losing control. Well, we're in that same sort of time period. And so there were some tribes that were still litigating their cases. And out of Wyoming, the tribes on the Wind River Reservation got a fabulous paper water right, fabulous. The case was appealed up to the Supreme Court. We know because, is it the justice who passed away, his name will come to me. When he apparently left instructions that as soon as he died, all of his papers would open up, which is uncommon. Usually you wait quite a few years. But because his papers were opened up, we learned that Sandra Day O'Connor had recused herself from that case. Had she not, that case would have gone in a very, very different direction. But 2 points of that story. In Indian country, we learned, whoa, we know what's going to happen if we go to the Supreme Court. Outside of the other thing that we learned, and I don't know if this is true, but what I've been told is that to this day, that tribe hasn't been able to put its water to use because of the animosity. Because as everybody in this room knows, it takes money to put water to use, right? And so that's the third point. So why do we have the tribal water rights settlement movement that we're living in today? Because as everybody in this room knows, I was briefing somebody on this conference back home, back at Navajo, and he said, "So you're a bunch of water nerds?" I said, "Yeah, we're a bunch of water nerds." But what we get out of settlement is being able to put our water to use. And we haven't been able to put our water to use really for equity reasons. That's a big term. But by settling, it's not just the tribe that benefits, but it's all citizens of the state, right? And it's all of our neighbors, because everybody benefits when tribal communities benefit. I think I will wait to talk about Navajo Nation versus Arizona, because I think it'll be a little bit more fun for some of the future conversations. And prelude, it's about Justice Gorsuch's dissent. And if you don't know about the dissent, you can get on your phone, and I think you'll be interested to see who signed off on that dissent with him.
Okay, thank you. And again, this is just a brief introduction of some background to frame some of our further comments. But Mike, do you want to think about, from a United States perspective, what would some of the strategies be that the U.S. could employ to deal with the context of either pending litigation or threatened litigation in the basin?
Thanks, Tanya. I think from the U.S. perspective, it's what it always is, which is let's keep pending litigation pending as much as possible. It's always there. It's always an option. But it's really, I think, from my perspective, and I think a lot of others who have served in the positions that I have, it represents failure. And failure should not be an option here. So a couple of things that I think, as a threshold, keep doing what you're doing. So I know tensions are high, relationships are frayed, but the bottom line is continuing the investments that are being made right now because of the resources provided by the Bipartisan Infrastructure Law and the Inflation Reduction Act has true value, because those are improvements in our system. They allow for people to think with more flexibility about how they manage water. That has a lot of value. Continue to negotiate and try and build on the good faith and discussions ongoing. Northeastern Arizona Indian Water Rights Settlement Act. Huge opportunity to continue the longstanding trend of getting settlements done, getting giving tribes resources, and then giving tribes opportunities to be part of the solution, much like Gila River has, pursuant to the 2004 Arizona Water Settlement Act. So I think, creating that type of flexibility, goodwill, progress is still important during this time in which the feds are going to be the focus of a decision-making process, because there needs to be operating guidelines in place post-2026. And so I would pitch it this way, because I've thought about it. And folks like me, on the one hand, you sit there and say, geez, I wish I was still in the game, because it would be a chance to live in interesting times. And then other times you think, my God, am I glad I am out of that game, because these folks currently seem like more of a handful than the folks that I worked with a while back. But I won't tell you which camp I'm in right now, but it doesn't preclude the fact that you think, what would I do if I was in that particular position? So the bottom line is, whatever people are thinking about litigation, and last time I checked, the 10-year accounting for flows from the upper basin to the lower basin is about 86 million acre feet. So we're not on the precipice of any, compact call litigation at this point in time. So people are going to be responding to a federal decision about operating criteria post-2026 in the absence of a consensual agreement amongst the parties, much like existed in 2007, this time with the tribes wrapped in a lot better than they were in 2007. And so from my standpoint, it's the irrelevant but fun to talk about Mike Connor 8-point plan. So my 8-point plan that you all are going to focus your litigation on is, one, start with using all the tools in the Secretary's toolbox. And I think they're substantial, and I think they're broad, and I think, working upper basin down, continuing to look at how to use the CRSP units to support deliveries and ultimately releases from Glen Canyon Dam. That's part of the paradigm of what's been done over the last several years. Make a cut. Establish that justified release, that schedule of releases from Glen Canyon Dam. People have put their proposals on the table. Reclamation has great technical expertise. Reclamation can put the record together about what should be the delivery schedule from PAL. Oh, by the way, to be credible in that aspect, continue with a very aggressive set of investments and work on the infrastructure needs and a remedy for the release problems that exist with the bypass tubes at Glen Canyon Dam. That's got to be part and parcel of your release schedule. Establish an aggressive, justified schedule of releases from Lake Mead, otherwise known as reductions to the lower basin states. I think there's a need at this point in time to deal with the reality of evaporation and system losses, and so seek a decree modification of the Arizona v. California decree to allow in the consumptive use determination that you include of allocating the evaporation and system loss to the beneficiaries of the system overall. I'd be asking the folks who, in theory, would be working for me, what about those beneficial use standards that were put together in the early 2000s? We should be looking at bringing back those and incorporating them into an operating plan. And then fundamental is to how do we create mechanisms to protect tribal interests pursuant to what I still believe is a very significant responsibility of the Secretary, a trust responsibility to tribes to create opportunities to ensure that they get value for not just the adjudicated or settled water rights, but the actual value of using or not using that water. And then obviously need to continue with system conservation activities wherever you can, recognizing everything kind of goes out the window post-2026 and you don't have those forbearance agreements that have been the model for continuing on with conservation activities. There still be willing partners, I think particularly in the lower basin, to engage in those type of agreements so that system conservation at a high level can still take place. And then finally, you've got to continue to negotiate with Mexico to bring them into the community of the water users who need to take reductions. Mexico has been a good faith partner overall. You can negotiate minute 33X, so that it can become effective upon the finalization of that plan that's going to dictate operations post-2026. I'll pause there because then I could segue into my view of at least the 6 or 7 claims that I see that would be immediately filed against the Secretary for putting together that plan and moving forward. But the last thing I'll just mention is most of that is within the Secretary's authority. And the things that aren't within the Secretary's authority, it's always within the Secretary's authority to identify those items, put them before Congress, and ask for help in putting together a system that works for everybody.
Thanks, Mike. Yeah, Jeff, I mean, you and I might be thinking of the same follow-up question, but I love the framing of thinking about this as the United States, doing its job, taking its role in terms of developing an operating plan, an operating structure. What happened in the context of New Mexico when state of New Mexico sued Commissioner Connor about the operating agreement in the lower Rio Grande?
Well, let me answer that question first, and then I did want to just sort of reiterate one point. But that is, so, you know, the Texas versus New Mexico litigation in large part did start when New Mexico sued the Bureau of Reclamation. And so there what had happened is you had an operating agreement that was long overdue and was ultimately negotiated, but it was negotiated as between a district in New Mexico and a district in Texas and Reclamation. It didn't involve the states, and there was already the Rio Grande Compact was in place. And so one of the problems there was simply that you didn't have all the right parties in the room talking about the things that they needed to be doing. So once that came out, New Mexico reviewed that for some time. There was initially litigation that was filed in federal district court. That led Texas to say, you know, we really don't want to be fighting this battle in federal district court in New Mexico, so they filed an original action in 2013. Here we are, over a decade later. We've taken over 150 depositions. We've had 3 different special masters. We've had a number of attorneys come in and out. We've been up to the court twice. I guess the good news is to say we're halfway through the first phase of trial. So, but you know, so it started off a very long series of litigation, which I'd like to think we're close to resolving, but I can't say that with any degree of confidence. But the one thing I did want to point out is we're sort of talking about losing control of the solutions and the idea that the court is ill-equipped to craft long-lasting solutions, and that is you don't have to take our word for it. And the reason is the court has told us that. It's told us that over and over and over. It's begged states and parties to resolve these kinds of water cases. And I'm going to read one of my favorite quotes about that because I think it's helpful. This is from the Colorado versus Kansas case of 1943. So this is the court speaking, not me. And they say, quote, the reason for judicial caution in adjudicating the relative rights of states in water cases is that while we have jurisdiction of such disputes, they involve the interests of quasi-sovereigns, present complicated and delicate questions, and due to the possibility of future changes of conditions, necessitate expert administration rather than judicial imposition of a hard and fast rule. Such controversies may appropriately be composed by negotiation and agreement pursuant to the Compact Clause of the Federal Constitution. So that's just, again, important to think the court itself recognizes its own limitation.
Great. And so in the context of that framing, do the risks of litigation help or hinder progress towards negotiations? And maybe another theme is what we've seen in this basin previously is setting aside a legal claim or setting aside the rights that you want to have protected, reserving your rights for future discussions. How does that play out?
Yeah, I'll just jump on that point. I think, you know, litigation, hydrologic, anything going on socially, disasters, which we have more, all of those are risks to the system. So litigation is just yet another risk to the system and how that disrupts the certainty with which the system is operated and that water is provided to folks who have to not just plan for this year, but 5-10 years out easily. So that's the history of this basin over the last 25 plus years, is taking the steps necessary to manage that risk. Hydrologic, yes. Litigation from a tribal perspective, certainly with tribal claims and dealing forthrightly with tribes as sovereigns to resolve those claims, trying to invest in the infrastructure necessary to withstand the extremes that we face in the system. So I think litigation, to get to the heart of your question, is a great motivator for coming to a consensus. And, you know, going back to my first point, there's a lot of goodwill, value in celebrating, coming together, and addressing those risks and putting together a plan that will withstand, you know, the last plan 20 years with some modifications. But that's a great feeling. Failure is the opposite of that.
I think I'll jump in, Tanya, because so for those who followed Navajo Nation versus Arizona, and is there press in the room? Is there any press? I'm just
Sure.
curious because,
I'm sure.
you know, I've been talking to the press for a few years now because of my good friend Ann Castle. She forced me to do it. I was like, I'm not talking. But, you know, I found out they're human beings just like the rest of us. And their biggest challenge is how do you put everything we just said in 30 words or less, right? But the point of the story is, you know, Arizona versus Navajo Nation was filed in 2002, and it was a very different case when it was first filed. Went up and down to the Ninth Circuit. And to Mike's point about litigation being a great motivator, you know, as the non-lawyers are watching the lawyers, is it Charlie and who was the other guy? Charlie Cork and Chris Gil Nelson. Watching Charlie and Gil argue amongst themselves, right? How many of you non-lawyers know exactly what Jeff Kay is talking about, right? And you're just pulling your hair out because once you hand it over to the litigators, it's just in their world at this point, right? And the engineers are just going mad, right? And the joke I always say back home is the only difference between a water lawyer and an engineer is water lawyers know civil procedure. That's really all that separates us, because there's very little law, right, when it comes to water law. But the point of the story is, as what I couldn't say to the press when they were writing all of their dramatic stories about Arizona versus Navajo Nation is, we're actually in settlement talks. And I was thinking about it on the plane ride over. Why couldn't I say that? It wasn't because we don't even have a confidentiality agreement. It's because it would confuse the heck out of the reporters, right? It wouldn't be consistent with their story. They didn't want to tell the story, and I think Jeff W. referenced it in one of his cases, is that, you know, you can get along and argue at the same time. And you develop these long-term relationships, right? I mean, look, one of the great things about being a Native American is we revere our elders, you know, so different than mainstream culture. So I can't call myself an elder, but I can at least point to my gray hair. You know, when the new administration in Arizona came in, Governor Hobbs has been super supportive of Indian water rights settlements. There was question. Could Navajo and Hopi do it? My Hopi friends are back there. We did it. Could Navajo, Hopi, and the state parties do it? My state party friends are out there. They're waving at me. We did it. Thumbs up. And I was telling these young people in the governor's office, we're old. A lot of us, we just want to get this done, right? Because it's the right thing to do. And sometimes, you know, as humans, we have to put our egos on the shelf. Charlie and I always see. I'm sympathetic to Charlie, so I keep forgetting the other guy's name. I'm Charlie. I'm the one saying settle, because it's better if one of the things Jeff said in preparation is, when you come into this work, you look back and you think your predecessors did a bad job, and you realize, oh no, they were cutting deals so they could build their communities. They were cutting deals because these were their priorities. So to the extent, there's kind of two takeaways we talked about when coming to this. A lot of people forget what happened in Arizona versus California. It's like we've all forgotten about COVID, right? Like, did COVID happen? We have such short memories. But I do think, to Mike's point, getting back in the courtroom and feeling that loss of control and having the non-lawyers remind people, we're here to better our communities, not to write the best memo to 25 people in a department. And I'm really sympathetic to Jeff's recitation from what the court said about the sovereigns, because for those of you who've been watching Indian Country and watch the water rights settlement movement, that's our mantra. We are a sovereign, and as a sovereign, we have to make the hard decisions. And that's what leadership's about. So I hope that all makes sense. Sometimes people who know me know that I kind of go in circles, but hopefully that makes sense to everybody.
Well, I just want to add a very obvious risk of litigation, which I understand the question to be, which is you might lose. I mean, we all really fall in love with our position, right? But the court's going to make a decision. It tends to be pretty black and white. I mean, that's something that, for example, in Texas versus New Mexico, we're grappling with right now, right? I mean, in the lower Rio Grande, which that case deals with, if New Mexico loses the case, it's crippling on both the municipalities there and the agricultural community, and that's a big deal. And it matters a lot then to try and figure out a way that we can work with our sister states that does allow both New Mexico to get the water that it needs and Texas to get its fair share of water. And I'm happy to say, at least among the states, we've been able to do that because both states recognize sort of the needs of each other.
I know there are examples from California.
Well, no, I just thought someone should be a contrarian a little bit here. And there are occasions where I think it actually does make sense to file the action. And, that's maybe my lawyerly training here. But, as I was talking about with Jeff, the other Jeff, that it has to be very narrow and focused. And I think it also has to be a case where the reason progress isn't being made, the reason something isn't being built or being enacted or whatever is because you have a fundamental legal issue between the two parties and that needs answering so you can move forward. And I think if the parties can really narrowly focus it, then that is where the courts can do their job. Where they don't do a good job is where it's really a policy issue, and we're asking them to resolve a policy issue, which is kind of what really Arizona versus California was. And then I think the other major, sometimes side benefit of that litigation is the new law firm of Kightlinger and Trujillo is going to profit wildly on this, and we're here to resolve basin disputes. But no.
Can I join?
I was going to say
and Connor.
One of our panelists
And the other Jeff.
who's going to remain anonymous said if things continue to degrade in the Colorado River Basin, perhaps we'll all make a great living in the litigation world. And I think, that's not the motivation that's driving the discussion of this panel, but I think it's the reality of these longstanding cases.
Well, I just want to jump in on what Jeff said, and that is, I agree there's a time for litigation. There is a very narrow band which courts are good at answering. And I'll give another example, and that is Kansas versus Nebraska, right? So there you had a discrete legal question. The question was some version of how do you have to account for groundwater depletions to this surface water compact, the Republican River Compact? The court answered that question through summary judgment. And once that was resolved, then the states sat down to do the hard work of trying to resolve, okay, now we understand the rules of the game, and now we're going to figure out what this should look like going forward.
I'm going to jump in and do the counter to the counter a little bit. But, I mean, I would agree that sometimes you need to, put up and not just shut up. And there's a great scene. I'm old, so I'm going back to the old True Grit, like the 1970 version, and I've even forgotten the names, but it's Tom, whatever his name is, and it's at the end of the movie, and he's sitting there, and Maddie's got a gun trained at him, and he's going, what are you going to do with that? And she shoots him, and he goes, you shot me. I didn't think you'd shoot me. Sometimes you got to shoot to get people's attention. But the counter to the counter is that, these things tend to go just full circle. And I'll give an example of litigation from Corps of Engineers perspective involving the tri-state water wars of Florida, Georgia, and Alabama, concerning management of 2 river systems, most predominantly the Appalachia, Chattahoochee and Flint River system. And, ultimately we're reading, it's almost similar to Texas v. New Mexico. The Corps is managing the system. Alabama sued the Corps over its management of Lake Lanier. And Florida had joined that litigation, but then Florida decided to file an original action in front of the Supreme Court seeking an equitable apportionment of that system. That was in 2013. It took to 2021 for the court to issue a 9-0 unanimous decision, 12 pages, to say, sorry, Florida, you didn't even meet any of the thresholds for meeting the threshold requirements for us to engage in an equitable apportionment of the system. So they go back to just litigating against the Corps and its operation of the system, and after 10 years of litigations on the Corps' master manuals, its operating plan for that system, they had an agreement last year where the Corps is going to go back one more time and analyze some specific flows that were negotiated by the parties. The Corps is now just going through the aspect of incorporating and updating its NEPA documents to what hopefully will be it accepting those flow parameters at the 4 points in the system. And it gets back to negotiating the outcome, and it took 10 years of litigation, getting all the costs, freight, relationships, et cetera, to get back to the negotiating table.
And do you think that's going to be the end to litigation, or will there be additional challenges after that gets sorted out?
I think it'll address the litigation that the sovereigns have bought. Whether there be other interested parties, that remains to be seen.
So going back to the framing of, the risks of litigation, or potentially the threat of litigation being a motivating factor to bring parties together, is there a context where you could have a mediator, or I know in Supreme Court litigation we have a special master that's oriented towards trying to help parties resolve their disputes. Does having that mediator role help, even though these are very, very complicated kind of situations?
So I think that a person like that, whether it's a mediator, an arbitrator, I'm going to throw out Rivermaster as well, and I'll explain why in a second, can be very helpful if the parties accept what that person is saying. And again, to give an example, in one of the cases, Kansas versus Nebraska, the subsequent sort of litigation over settlement issues, there were provisions in the settlement having to do with arbitration, interstate arbitration. But they weren't binding. The parties didn't look at them as very helpful, more like a speed bump on the way to filing an original jurisdiction case. That wasn't helpful. But if you have a mediator or a party that is in a position to be making decisions on things where decisions can be made and there might be differences, I think that can be immensely helpful. And there I'm going to give the example of a Rivermaster. Now, the court has made it crystal clear, because we've asked a couple times in cases we've won that for a Rivermaster, and the court just brushed it aside. So I doubt that'll happen again. But the Rivermaster in the other Texas versus New Mexico case, the Pecos case, has been immensely helpful for managing the relationship between those two parties. And because what happens there, and this is coming from the upstream state where the Rivermaster is doing most of his work, but there the Rivermaster is able to, for accounting issues, for the types of things that fall within the purview of a Rivermaster, there's somebody who can answer these kinds of disputes. They don't fester, they don't last, and the states can then get past them because there's a resolution, and they can think about the bigger picture and the bigger issues.
I'll just tell a funny story. We were, as part of some settlement talks a long time ago where the mediator drove everybody so crazy. That's what brought everybody together. So again, I mean, it's human nature. Like, what do we agree on? And I do want to be part of the contrarian group, because I would be remiss if I didn't point out that, you know, the Gila River tribe, the Gila River Indian community, who I believe is here, and Mike referenced them. There are 5 Arizona Supreme Court cases. You know, Arizona is a Gila 5. So yes, there are times when you have to litigate to get certain questions answered. Absolutely. Tanya had referenced Navajo, Arizona versus Navajo, the recent Supreme Court decision, and it's, to me, it's just such an interesting read, even for a non-lawyer, because the very first thing they're arguing about between Kavanaugh's majority and Gorsuch's dissent is, what is this case really about? So when Jeff Kay talks about, well, if you have a narrow decision, well, I mean, a narrow pleading, yeah, if you can even get the judges to agree that you have that pleading, you know, there's still that concept of control and loss of control.
So since you had a funny story, I have one as well. So, and just seeing Secretary Babbitt here reminded me of it. When we were doing our quantification settlement agreement and had so much battling intra-California and then the other states piling on, we brought in Abe Sofair as a renowned Middle Eastern dispute negotiator / mediator out of Stanford to help mediate. And after 3 months of us, he threw up his hands and said, I want to go back to the Israelis and the Arabs and away from you water folks. And it was a good lesson in how intractable our issues sometimes are, but also how down in the weeds we are. But I will say, as a mediator, it didn't work, but as the secretary playing in a tremendous role in pushing the party, that has always been, you know, the path to success when we've had our successes.
Can I ask you about that, Mike?
I agree with Mr. Kightlinger.
So in the context of additional thoughts or comments about how, you know, how litigation may play out in this basin, I think the framing of, if there is a narrow question to be decided, how do you keep that under control and not let the court or additional pleadings processes spin the litigation into something that is not what you intended? And I think there's some examples of that that are out there as well. Did anyone have thoughts or comments on how the complexities can be expanded, whether it be parties or claims or outcomes of decisions?
I'll jump in since I think everybody's going to attack the secretary's plan. I'm going to disavow ownership of it all right now. But getting back, I will just say, having had the true joy and great learning experience of working for Bruce Babbitt, that in particularly my role in the Arizona Water Settlement Act and the negotiations involved in that, I was fortunate to be part of the team. There is no better master strategist than using the secretary's position to craft the conditions necessary to bring the parties together. So I just was a belated response to you asking me about that. I got to see it in action firsthand. So I just wanted to acknowledge that since he's sitting here right in front of me. That was truly a master work from a master strategist. So I laid out this plan potentially of all the things that the secretary of the department can determine as part of, you know, post-2026 operating plan. So, you know, what would follow up would be probably, depending on how it's laid out, but here are all the possible claims of IC. I still see this coming as a, you know, lawsuit against the department and the secretary from folks who are not satisfied or end up having reductions in water available as a result of this. So obviously there's the contract holders who expect a certain amount of water and a certain priority who would be potentially filing claims. There would surely be a challenge to the secretary's authorities under the law of the river, whether those that plan properly interpreted the breadth of those authorities. There would be questions about the authorities the Secretary has to act to protect public health and safety, which would be part of that plan, depending on how low water got in the reservoirs and the releases that would be required. There would be clearly an Administrative Procedures Act claim. The Secretary's, it gets to authorities, but also gets into the record that's been developed to define the releases under certain conditions at certain, capacity of the system, or, maybe it's reservoir elevations going back. I think depending on how it played out and addressed whether it is bringing real value to tribal rights, I still think that there are potential claims that tribes could have against the Secretary for not properly fulfilling his or her trust responsibility based on the totality of the Secretary's control over the system. And so I think, notwithstanding the Navajo Supreme Court decision, I think those claims would still be could be put together. Then there's obviously the environmental laws, whether you're addressing the Endangered Species Act issues, whether you've properly considered everything under NEPA, whether you're truly taking care of some of the environmental needs that have been able to be addressed through some of the agreements. Those are all at play in any action taken by the Department of the Secretary.
I'm going to give just some views about this idea of litigation, especially what this litigation might look like, spiraling out of control based on sort of educated guesses based on past cases I've been involved in, what the initial sort of procedural posturing might look like, right? So we all know you file a litigation, even in district court, and there's a lot of sort of wrangling to get the case right-sized and moving towards the resolution of the substantive issues. So this is all before any substantive issues are out there. So the first thing you do, you've got this process in the Supreme Court of filing a motion for leave to file your original jurisdiction case. That's going to take a minimum of 12 months, probably more like 18 months. Okay, so now the court's accepted the case. Next is going to come almost certainly a motion to dismiss, and that is going to involve a ton of briefing, an awful lot of arguing before a special master. That's going to take at least another 12 to, I've seen it as long as 2.5 years before that gets resolved by the special master. Now that motion to dismiss is going to go up to the court because everybody wants that. That's a meaningful point in the case, and so the court's going to hear that. And now you're looking at at least another 1.5 years. So now you're at basically 4 years, and now the court has said, okay, the case can go forward now. But you haven't figured out the size of the case yet. So now you're going to get a huge battle over who are the parties. Are they the compacting states? Are they states the original litigation? What about other stakeholders? Which of them have meet the kind of high bar for non-state or tribal participation in an original jurisdiction case? And that's going to be another 1 to 3 years would be my guess. That likely goes back before the court. And now you're back, I don't know, maybe 5 to 7 years, hard to tell exactly how long. Now we're going to talk about, okay, what are the claims, right? So you have the original, whatever complaint is filed, but we have to talk about counterclaims, cross-claims, those sorts of things. All of those things have to be argued about. So you're looking at 5 to 7 years of that kind of litigation, and that's before discovery really starts in earnest. So kind of a sobering time frame, I guess.
And along that same time frame, the hydrology is shifting, and the operations haven't ceased, and people haven't stopped planting crops or drinking water in their homes. So it's dynamic. Did you have an ad?
I just wanted to jump in because I think, because as we predicted, our panel's going to go by very quickly. And I wanted to jump in because Mike's made a couple of comments to the trust responsibility, and I made that reference to the journalists not fully understanding, wait a second, how can Arizona sit down and settle with you? And how can the United States do this? Read the Supreme Court case. These are horrible people. Well, they're not horrible people, first of all. And, it's legal fiction, right? That's the legal world. And then there's the reality that Tanya talked about. And remember, COVID was happening. And I think if you go back and read that Ninth Circuit decision, they just took notice. The court took notice of COVID and its effects on the Navajo people. There's a direct correlation to the lack of access to clean drinking water. And I was on a panel very recently with Bob Anderson, the solicitor for the United States, and he said exactly what Mike said. You know, yeah, the decision came up. We still have a church responsibility. And so we are going to pursue and support this settlement. So who is it that, you know, who from the United States then is pleading the things that you see in that? And that's a group of people from US DOJ. So I think it just, the point of that is the complexity of all governments, including tribal governments. Because I think if you really listen to the quote that Jeff Wechsler read, you know, that's really what the court's getting at. It's governments are complex entities, and you've got a lot to weigh. We're just a court, and we don't have to weigh all the same considerations. But what I wanted to read to you, and this is a little bit long, but I think it's worth it, because it's Justice Gorsuch that wrote this, and and the people who signed off on it were the three women, and people are not including Amy Coney Barrett, but it's remind me, Jeff, you're the expert in this. The three, Jackson, Kagan, Sotomayor. And people are very surprised to hear about that combination of people. Well, for people who practice in the Supreme Court, one of the things you do is you pay very close attention to relationships. And it's very well known that Gorsuch and Amy Coney Barrett are very, very, very close. So you're going to watch that relationship, and is Gorsuch going to influence Amy Coney Barrett? And if he does, you've now got 5 people on this side. And let me read the side to you. So this is Justice Gorsuch's dissent, you know, saying, Kavanaugh, you got it wrong. So this is word for word, where do the Navajo go from here? To date, their efforts, sorry if I tear up, I think this is very well written. To date, their efforts to find out what water rights, excuse me. To date, their efforts to find out what water rights the United States holds for them have produced an experience familiar to any American who has spent time at the Department of Motor Vehicles. Yes, the Department of Motor Vehicles. I think there's some tribal ladies in there clapping. Clap all you want. The Navajo have waited patiently for someone, anyone, to help them, only to be told repeatedly that they have been standing in the wrong line and must try another. To this day, the United States has never denied that the Navajo may have water rights in the mainstream of the Colorado River and perhaps elsewhere, that it holds in trust for the tribe, that the United States holds in trust for the tribe. Instead, the government's constant refrain is that the Navajo can have all they ask for. They just need to go somewhere else and do something else first. The Navajo have tried it all. They have written federal officials. They have moved this court to clarify the United States' responsibilities when representing them. They have sought to intervene directly in water-related litigation. And when all of those efforts were rebuffed, they brought a claim seeking to compel the United States to make good on its treaty obligations by providing an accounting of what water rights it holds on their behalf. You see the similarities? Mike said, you all are going to sue the secretary, right? Who are we suing? At each turn, they have received the same answer: try again. When this routine first began in earnest, Elvis Presley was still making his rounds on the Ed Sullivan Show. I'll stop there, but what Gorsuch does from there on out is he lays out the game plan. He tells you how to plead it. And so when Mike talks about, you know, there are some tribal claims out there, we have somebody on the Supreme Court advocating for us. And for those who, again, for the non-lawyers, again, it's 9 people. He's got 3 on his side. Maybe Amy Coney Barrett will switch. The other thing that's happening is because Gorsuch is so interested in Indian law, and he comes from the West, which is the other reason we like him, there are hundreds of students now taking Indian law so that when he reads their resume, they'll pick them to clerk for him. So this one man, and dare I say it, this one white man is having a huge, huge impact in I will characterize it in a positive way for tribal claims.
I just wanted to respond on 2 levels real quickly. So I appreciate the tears you had when reading that, because the first time I read Gorsuch's majority opinion in McGirt at the end where he talks about perpetuation of a wrong doesn't make it legal.
Well, the 2 things happened that week. The Washington, D.C. team changed its name, which was shocking. I went to undergrad in Washington, and I was asked point blank, among these elite students, why shouldn't Washington have that name? And never in my life would I think they would change it. And then, like, the next day, McGirt comes in. And Mike and I were on a call, and we were like, what world are we living in? We're living in a world where, the arc of history bends towards justice.
Yeah, and on that point, it's good to know about, I didn't know about the relationship with Amy Coney Barrett, but I would just say, correct me if I'm wrong, my own sense, and I'm not a student of this, was that Ruth Bader Ginsburg was not very good on tribal cases early in her career. But she, I don't know if it's the right way to say it, a switch flipped, but she was really good at the end of her career.
Okay, but I'm going to let you keep that judge hat on for a minute, but I thought we're getting close to the end of the session time. We have reiterated a number of reasons why interstate litigation is complex and the uncertainties that exist with respect to that situation. In terms of just playing out a little bit of a role play or kind of a for fun type of a concluding process, wanted to try to map out some of these complexities a little bit more and think through how things might be playing out. So I'm going to have Jeff and Jeff kind of somewhat switch hats for a moment, and Jeff W., kind of put yourself in the context of a lower basin position and tell us what an opening or closing statement might look like. And then Jeff K. can do the same thing from an upper basin perspective.
Yeah, I don't know. It may not be as refined as it might otherwise be before the court, but I'll give my best, yeah. Madam Chief Justice, may it please the court. The question before you, Justice Becker, is whether it is fair for all states in the Colorado River Basin to share in the burden of water reduction. The answer is yes. Let me start from 2 principles. First, we need to think about the whole basin as one interconnected system. There are elements of both plans that suggest that kind of thinking is necessary. Second, let me remind you that the lower basin is home to 3/4 of the Colorado River Basin's population, most of the basin's tribes, and some of the most productive farmland in the country. The court has long recognized prior development as an important factor when it is crafting equitable relief. With those principles in mind, the lower basin state's framework appropriately relies on measures how much water is in storage in the basin and provides a method for distributing water cutbacks accordingly. Under that plan, very meaningful reductions will occur in the lower basin. As we know, the lower basin system is run by reclamation, and water users must have contracts to receive water. That means the lower basin proposal is real and enforceable. The upper basin must reduce their fair share. There also needs to be similar accountability and enforcement measures in the upper basin. Thank you.
Not bad, but no. Nowhere near as formal as Jeff, a true litigator. But I think if I'm sitting in the shoes of the upper basin, there's a couple of points I would be making. One is, how the compact starts out, which is we're going to have an equal division here. And one side, one basin has been using up to its entire apportionment, whereas one has gotten nowhere near it. And so when we're going to be reductions, the reductions need to come from, and to be shared equally, you got a long way to go before you reach the upper basins amount. Secondly, a second point I think I would make, assuming what triggered this, what action has triggered this litigation. And presumably, I agree with Mike, what probably is going to trigger it is some action by the secretary to short somebody's water delivery. And if you're doing that, what is that trigger? Why is the upper basin potentially being shorted in some fashion by the secretary? One of the things I think that's going to be a very important consideration is what's the role of climate change? We now have a reduced river here, and a reduced river cannot meet everybody's paper obligations. And so we have to go back and say, this obligation is no longer feasible anymore. It is no longer practicable. The world has changed, and that is an excusing factor to all of this. So I think those 2 points are strong points.
Okay, so as this is playing out over the next 2 decades, the U.S. is following along. Mike, do you have any observations as to how to respond to this world that we're in now?
Yeah. I hope I'm out of that world,
Yeah.
litigating matters in front of the U.S. Supreme Court, but I think, if I was, I can't help but think about this in terms of probably more of a policy perspective or a reality check or whatever you want to call it. The basin's at, 75% of the hydrology that was allocated back in the 20th century. So you look at about 12.5 million acre feet, if that's what it's at, versus the 16.5 that's been allocated. You've got that reality, plus the reservoirs are now about 39 and 33%, Powell and Meade respectively. Time is of the essence. And so I think the secretary has to act. I think through multiple administrations, Republican, Democrat, it's been demonstrated the department's strong commitment to continuing to support agreements that are developed by the parties in an ever-growing, by parties, it's not just 7 states, that picture that Kevin Fedarko showed and when he did his presentation. It's a broader group of folks at the table, and that's a good thing, and the department will support that because that's the best way to have at least peace in our time or get through the next 20 years. No solution is final given the dynamic of our current climate system and how quickly that changes and the extremes that we're facing, but that's always going to be the preferred approach. But inaction is an outcome that is completely unacceptable. I think anybody coming in to the department in a leadership role will understand that, and so they'll do their responsibility of making the best decision possible to have a sustainable plan that can move forward and achieve as much equity to everybody's perspectives. And that's the reality that somebody's got to make a decision and operate the system. And hopefully the 8-point plan I laid out is so obnoxious to a lot of you all that the idea of letting a group of folks at the department or one person at the department make that decision is unacceptable, and that leads to renewed effort to get to a comprehensive solution that involves all the right folks.
Excellent. And Justice, you've listened to this discussion, and I want to throw it into your hands, recognizing you can always make everyone go to mediation too. So.
Amazingly, somehow Justice Becker got on the court through the mentorship of Justice Gorsuch, and she reminds the parties that Justice Gorsuch said that the court, so Justice Becker is going to remind the parties what this esteemed court has said. Very recently, this court has, and this is a dissent, has said that that the Supreme Court recognizes that the Navajo, quote, may be able to assert the interests they claim in water rights litigation, including by seeking to intervene in cases that affect their claimed interests. Quote, after today, it is hard to see how this court or any court could ever again fairly deny a request from the Navajo to intervene in litigation over the Colorado River. So I'm curious because I've heard the federal government here today, but I haven't heard them explain how they're going to address these outstanding tribal issues. So I'm going to turn back to 1943 and remind both of our litigators, the Jeffs, who are representing the states, that I, as a product of Justice Gorsuch, an originalist who believes in this federal republic of the states having full authority, that the reason that this Supreme Court must exercise judicial caution in adjudicating the relative rights of states in cases, specifically water cases, is that while the Supreme Court might have jurisdiction over such disputes, they involve the interests of quasi-sovereigns, present complicated and delicate questions. And I will add, the role of sovereigns is to serve the needs of the people, and I would also add of the resources that exist. And due to the possibility of the current changed conditions, this really necessitates expert administration, and not administration that I don't have any expertise in. So I am going to do exactly as my law clerk, Tanya Trujillo, has advised me to do. I'm going to order you to enter into mediation and do not come back to me until you have also addressed the tribal concerns as well.
Yay.
Thank you. King Solomon.
Okay, well, thank you very much to all the panelists for participating today and for the discussion. I think, we barely scratched the surface of some of the complexities that we might be actually dealing with if we were in a litigation context. We've successfully avoided that over the past 20 years, and I would invoke the spirit of Commissioner Johnson to not let us throw up our hands, but to keep moving forward. So thank you all for being here this afternoon. We're happy to host the free drinks on the patio after this.
All on Tanya.
Thank you very much.